Hi, folks. So I've made a few posts about the recent Supreme Court's decision in AutoZone. And so what happened um, in that case was the injured worker, which is the basis of the case, Shoemaker, filed a motion for reconsideration to the Supreme Court's decision. Um, and then so the Ohio Association for Claimants did as well, and the Ohio Association for Justice submitted a supporting memo as well. And then the AutoZone submitted a memo in opposition to the injured worker Shoemaker's motion for reconsideration. So, and Shoemaker's, and again, that's the injured worker in this case, position is that the Supreme Court in their decision stated the following: there is no dispute that AutoZone terminated Shoemaker following his September 5th, 2020 altercation with a coworker for violation of its employment policies. So, and what Shoemaker is pointing out with is, well, that's the employer stated that perhaps, but the Ohio Department of Jobs and Family Services did not find that the termination was a just cause termination. So, and they approved Shoemaker's request for unemployment benefits. So, AutoZone terminated this guy. He applied for unemployment benefits, and you could apply for unemployment benefits even if you have a workers' comp claim, as long as you are working in like a light duty capacity. If you're completely taken off work, you're not entitled, you're not eligible for unemployment benefits. So this individual filed for unemployment benefits, and if you've ever filed for unemployment, you might have to go to a hearing, and it looks like they did, because AutoZone, obviously they fought against it, but Shoemaker won that hearing, and then AutoZone did not appeal that decision. And I think that is kind of very relevant, and it kind of throws into question whether or not, again, the 412356F kind of Supreme Court's theory is implicated, because the Supreme Court's theory is basically to be entitled to temporary total disability or temporary total disability compensation is there has to be, you have your injury, and then there cannot be an intervening thing between the injury and temporary total. So they're saying getting terminated is an intervening thing in your request for a temporary total, and that's the reason why you're not working at that time. It's because you got terminated versus you happen to be injured, and so therefore you're not entitled to compensation. So here's temporary total disability, and in between there's this termination. Okay, so you're stuck, and then since when you go to the analysis, the reason why you're not working is because you're terminated, and therefore you're not entitled to comp. So and they make a few more, essentially they're saying, since he was receiving unemployment benefits, he did not sever his entitlement to comp. Again, ODJF found it without just cause, the termination. The Ohio Association for Claimants Counsel, essentially their memo, again, was in support. And essentially, again, the Industrial Commission found that the ODJFS's decision that AutoZone job termination of Shoemaker was without just cause and was not an intervening superseding event to break the causal connection between the injury and the disability. And remember, Shoemaker received, the Industrial Commission granted him temporary total disability compensation at the SHO, and AutoZone is the one who filed the mandamus to the 10th District. So they're the one that filed appeal to the 10th District Court of Appeals. So that is the Ohio Association of Claimants Counsel's memo. And then the OAJ, again, this is like another organization. These are like attorneys that represent injured workers, are generally a part of this association. And again, same thing. And then they also discuss in this motion. I think this motion is written really, really well. And the reality is, one of the individuals who wrote this is John Goodman, And John Goodman's like a legal expert. If there's like if you know somebody who's like really into something, like they're into baseball statistics, or they're really into movie trivia, and they can tell you all the details about, the Star Wars movie or whatever. Well, this guy, John Goodman, is like that, except as to Ohio workers' comp law. So he's kind of a savant with Ohio workers' comp law. He's a really smart individual, really astute. So I think his memo is really well done. And basically, one of the things he points out to, and I don't think anybody can deny this, is that the Supreme Court's decision encourages employers to terminate injured workers, and leave injured workers with no way to challenge the determination. And I would tend to agree with that. And then the other thing he points out too is, if you read the Supreme Court's decision in AUTOZONE, it's really not clear if the Ohio Supreme Court really understands what issue they're dealing with. And he kind of discusses this because in the Ohio Supreme Court's decision, they reference the fact that, because you have a full weekly wage, and average weekly wage is based upon your prior wages that you made before the work injury, meaning you worked before the work injury. That implies that you have to be working in order to receive temporary total disability. And it's kind of, to be perfectly honest with you, that doesn't make any sense. And I don't know what happened with that part of the analysis of the Supreme Court's decision. I'm not sure who wrote that, but logically, in the Supreme Court's decision, it doesn't make sense. So either the logic is really flawed, or they don't understand that the FWW and AWW really has nothing to do with 412356F, but for the fact that that's the way you set the temporary total disability wage rate. And remember, FWW it's essentially the time immediately before the work injury, 1 week before, 6 weeks, whichever is greater, and then you get that for 12 weeks times 72%, whereas the AWW is all the wages divided before the work injury. So if you get injured on April 2nd of 2023, then from April 2nd of 2022 to April 2nd of 2023, you take all those wages divided by 52. That's your AWW, and you get 66% of that each week that you receive temporary total, if it's beyond 12 weeks. So I probably lost everyone there, but the point is that has nothing to do really with whether or not you're entitled to temporary total disability. So again, John Goodman's really smart. I tend to he's kind of a savant. He's kind of a guru. So I like his memo. So AUTOZONE wrote their opposition to Shoemaker's motion and the subsequent motion, and it's essentially there's a whole section about they're arguing procedural reasons why the request should not be granted, and then they also argue that Ohio Department of Jobs and Family Services decision has legally, in the fact that there was no just cause for termination, has no binding effect on other administrative or judicial proceedings. So, i.e., the Industrial Commission and/or Supreme Court can ignore the fact that this person termination was found to be without just cause, which is kind of weird. It's kind of a weird take, because you'd think if it's kind of like, do you not trust ODJFS's? Like, that's what they do, right? Like, that's their thing, is determining whether or not the termination was for just cause, i.e., it wasn't some retaliatory termination, or there was something wonky about the termination. Like, that's what they do. So why would you not trust their decision? But so anyways, that's what they're saying. So what I think might happen is, I think there's 3 different scenarios. And the other thing with this motion opposition, I mean, a lot of, when you're filing these sorts of things, even at the Industrial Commission, you kind of want to give the hearing officer or the adjudicator, or whoever is dealing with the issue, the judge or the Supreme Court justice, you kind of want to give them some basis to find for your situation. So And so in this case, the fact that they wrote, I mean, if you look at the other, like the motion that Shoemaker wrote and the memos in support of, they're not really that long. They're like a page or two a piece, maybe a little bit more. But this one, it's like a few pages long. So basically, they're like, hey, they're throwing everything but the kitchen sink at the court, and they're giving the court a lot of different options to say, okay, that looks good enough. We'll pick this thing out, and we will deny the request for reconsideration. That's cool. Thank you, AutoZone, for giving us that. Perhaps that's what they'll do. So that's kind of why you're throwing all these things. If you're AutoZone, you're kind of giving the court a lot of options to reject the request for reconsideration. So what do I think might happen? Okay, I think this is, there's an 89% probability that this first thing happens, and I think simply the Supreme Court rejects the reconsideration entirely. So I think there's an 89% probability that occurs. I think perhaps there's a 10 to 20% probability that the court grants the request for recon, but doesn't completely throw out the decision. It basically issues like a limited writ, and it says, oh, you know what, maybe in this case, since this person was, they were terminated without just cause, you're right, you caught us. We did kind of misstate that in our decision. Therefore, for you, Shoemaker, we'll reverse our decision as to you specifically, but everything else is copacetic. We want the 412356F to be interpreted in the capacity that we want it to be interpreted. Maybe again, 10 to 20% certainty or probability that they'll go that direction. I think there's a 0% probability that the Supreme Court grants the request for reconsideration and throws out the decision entirely, and then reverses and relies on decision of the 10th district. And that's probably what's going to happen. So what's the lasting impact of the Supreme Court's decision in AUTOZONE? Well, prior to 412356F, there was a judicially created doctrine called voluntary abandonment. And you kind of figure out when you hear judicially created doctrine, it was a doctrine that was created by the Ohio Supreme Court. And essentially, it basically said kind of what the second sentence, well, I'd argue the second sentence is the voluntary abandonment doctrine. Inscribed in the statutory code, but essentially, if you did something that caused you to be separated from your job, your voluntary action severed your entitlement to comp. So it's voluntary abandonment. You chose to do that action, and by your voluntary choice to do that thing, i.e., violate a no call, no show policy, testing positive on a drug test after the work injury. Having too many unexcused absences, that voluntary action by you severed your entitlement to basically temporary total disability compensation. Versus if you got injured and that injury caused you to be unable to work, then your inability to work is a result of, it's an involuntary choice, i.e., nobody actively chooses to get injured unless you're insane. Perhaps there are some people that like to get injured. I don't know. To each his own. But I would say the majority of folks do not enjoy getting injured, and even less folks like getting injured at work. So probably about 99.9% of injuries at work are involuntary, i.e., they're things that just happened. And you didn't want them to happen. And so if your inability to work is due to an involuntary action, then you're entitled to temporary total. So that's the voluntary abandonment doctrine, kind of in a very simplistic form. But in general, what ended up happening with the voluntary abandonment doctrine is it was kind of confusing, and it was interpreted in many different ways by subsequent cases, and then they had to deal with, well, what about this situation, and what about this situation? What if, For example, there's I call it the KFC case, or it's called Gross 2. What if you get injured and you violate a workplace or safety rule policy? You violate a workplace policy, and by violating that workplace policy, you get injured. So are you entitled? Does voluntary abandonment kick in then or no? Well, in that case, no, but that's the prior case law. But they had to deal with all these little scenarios that popped up, and it's just kind of messy, and that's what happens when you have case law that's kind of not the greatest case law, right? Because it ends up generating a ton of like requirement to interpret it. So nobody liked that. The plaintiff's bar didn't like it, obviously, for various reasons, and the defense bar didn't particularly like it either, because it was kind of unworkable, and it just created too much going to the Supreme Court and the 10th District to interpret this or that weird situation. So, and then finally, when everything came to head was they have this precision excavating case, and I've had other videos that discuss that. And essentially, the defense and plaintiffs bar lobbied the Ohio legislature to rescind the voluntary abandonment. So they explicitly, in 412356F, there's actually 3 sentences, and the third sentence says, hey, this revised code section supersedes voluntary abandonment and its progeny. So it's various cases that followed from voluntary abandonment. And generally, a lot of people behind the scenes, they thought it was the greatest thing, and it's like, oh, we finally came up with a solution. But others, including myself, were basically saying, hey, there's 3 sentences. The first sentence, it's not bad. The second sentence, you basically enshrined voluntary abandonment in the revised code. Why would you do that? That's not the smartest thing to do. Instead of, keeping Satan outside the house, you've given him a seat at the table. So now voluntary abandonment's right over there, but no longer is called voluntary abandonment. He's sentence number 2. And the problem is, after they kind of this code section came out, revised code 412356F, there was, with any new law or any new revised code section or any new case like this case we're discussing, there's always confusion. How do we interpret this thing? And so there was various cases, and this was one of the big cases, this AUTOZONE, the 10th District case. And the 10th District's decision came out, and it was great. It was fair, it was clear, it was unambiguous. There was it kind of closed the door for abuse by employers. An employer isn't motivated to terminate people, because if they terminate people, they still might not sever the injured worker's entitlement to temporary total disability compensation, as long as the injured worker is otherwise qualified for temporary total disability compensation. It was pretty straightforward to understand, and so there was not a lot of room for unfair decisions at the Industrial Commission. So I think it was a workable interpretation of 412356F. Now you have the Supreme Court's decision, and again, essentially, the reality is the second sentence was voluntary abandonment in the revised code section, but they kind of forcefully highlighted that the second sentence, they basically more or less got rid of the first sentence, and they kind of highlighted the second sentence. They're like, this is really important, and we want to hold this up. So if there's a hierarchy, because you're supposed to look at those 3 sentences, they kind of put the second sentence kind of has supremacy over the first sentence. And what ends up happening is it adds a whole level of confusion, of certainty into the mix. There's going to be a lot of litigation about this in the future. If you're claimants, you're not going to be happy, because you're going to get injured. You're going to work light duty, and then you're going to get terminated, and then you're not going to be entitled to compensation. I think the people who win out on this perhaps are defense attorneys, because you get paid per hour, and there's going to be perhaps a lot of, maybe not. I think the other thing is, I think claimants and claimants attorneys are kind of not really too excited about ringing the bell of the Supreme Court, because of the Ohio Supreme Court in its current makeup makes the decision like this in this case. I mean, the reality is they're probably going to make similar decisions that plaintiffs wouldn't particularly like in future cases. So, but nevertheless, there may be a lot of litigation that's going to benefit the defense bar. They get paid per hour, billable hours, so there's going to be more billable hours. There's more room for abuse, right? Because employers can terminate people in some questionable bases, and that would be, depending on how this gets worked. The problem is, back at the IC, are they going to look at terminations as, well, we're not going to weigh whether that was a just cause termination or a justified termination, and we're not, if an employer says somebody's terminated, then 412356F second sentence applies, or are they going to look at it and weigh whether it was just cause or unjustified? It's confusing, and it's going to be if they go with the first situation where they just look at, oh, was the person terminated? Okay, if that's the case, we're not going to weigh whether it's justified or not. The second sentence applies. Maybe that's a more simple pathway for the Industrial Commission. It's not really fair for the injured worker, but on the other hand, if you're asking the Industrial Commission to be weighing whether or not the termination was a just cause termination, then the problem is I mean, how long are these Industrial Commission hearings going to be? Like 2 hours long, 3 hours long, whilst we weigh whether or not the person was terminated for a just cause? They don't typically, hearing officers, they're not put in that position to do that sort of thing. I don't know if they're trained to do that sort of thing, but it's not clear how that's going to work. So maybe I don't know. That's what this case does. That's why it's a problem. So yeah, and again, it's, if an employer wants to limit their exposure, hey, find a reason to terminate somebody. And again, the other reason, I always say these videos, these workers' comp videos, is really your motivation as an injured worker should be to get healed, and then also to return to work, whether that's, again, in a full duty capacity, a light duty capacity, or perhaps in another career in vocational rehabilitation if you can. Unfortunately, some people are so injured that they're not able to work in any capacity ever again, and they're permanently and totally disabled. But for everyone else, you really should be striving to return to work. And so maybe this is going to delay folks' decision. Maybe, whereas in the past they might be like, you know what, I'm going to try to go back to work. I'm maybe not entirely healed yet, but I'm going to try to go back to the workforce. Maybe now they're going to be like, well, I'm going to delay it. And I don't think that's a good idea for anybody. I don't think it's a good idea for the employer. I don't think it's a good idea for the injured worker. I don't think it's a good idea for the state of Ohio. And so that's ultimately why I think this decision is bad, because it has a chilling effect on folks returning to work in a light duty capacity. I would hope if a new case goes up before the Ohio Supreme Court, they kind of look at it with that perspective, because I think the Ohio Supreme Court, like everybody else in Ohio, wants people working, and they want people returning to work if they're not. So we'll see how things play out. But that's the kind of the state of AUTOZONE right now with these requests for reconsideration. We'll see how that spins out. It is what it is. And the reality is, at a certain point, when the legislature and or the Supreme Court, continues to chip away at the workers' comp system, at a certain point, you have to question, is there really a benefit to the Ohio's workers' comp system in any capacity? Perhaps they just dissolve it, and then perhaps we go back to the workers' comp system reality, whereas if you get injured at work, maybe if it's a minor injury, you're just going to have to pursue it through your treatment, versus if it's a really big injury, then you're going to file a personal injury suit against your employer, and then all the PI defenses come into play. But also, you're going to have perhaps really massive payouts, because remember, workers' comp cases really only involve economic damages, and very limited economic damages, medical treatment and compensation. But perhaps, maybe it would be better to go to get rid of workers' comp. We give the $20 billion back to the citizens of the state of Ohio, and then maybe folks will have to get buy their own short-term and life-term disability policies, and that's how we're going to have to do it. Because at a certain point, when you continue chipping away at this thing, then it's almost kind of the benefit of the system is removed, and it becomes like a make work for a bunch of bureaucracies and a bunch of people working for this. And I mean, who are we benefiting? Are we here to benefit the injured workers, or are we here to benefit the people working within this system? So maybe that's what we need to do. And then if the people that very severely injured, they file their PI cases, and you get your Leisureman, attorney Leisureman, or Mordarskis, and they get involved, and then we have this employer getting sued for this serious injury, and you get $1 million payouts. Maybe that'd be better. I don't know, but bottom line is, I don't know. At a certain point, there needs to be a balance of in favor of injured workers, and in regards to how these decisions are made and how these cases are decided. And the 10th District, I think, was a fair decision, and it was claimant friendly, and it was not adversely negative towards employers. And I think the Supreme Court's interpretation of that same fact pattern is disproportionately negative towards injured workers, and disproportionately beneficial for employers. So anyways, this is Attorney Kip from Malik & Malik. This is the state of things right now in Ohio with this AUTOZONE case. As I say at every single one of these videos, if you suffer a work injury, particularly in light of things like AUTOZONE, you really need to get a workers' comp attorney involved with your case. This stuff is so complicated that it's going to pay you, you're going to be paid out, and it's going to be far more beneficial to get a workers' comp attorney than it is to do it on your own. And perhaps if you do it on your own, you'll do fine and everything will be great. But maybe that happens 1 out of 10 times, but I guarantee you 9 times out of 10 times you're going to run into complications. So talk with an attorney, get an attorney involved if you need to. Talk with one attorney, talk with 10 attorneys, find the attorney that you vibe with. Ask your friend, family, neighbors, coworkers, doctors, priests, rabbis, imam, whomever. Say, hey, do you know any good workers' comp attorneys? And they'll know somebody. So go to that person. Otherwise, if you have questions or comments or concerns, by all means, leave them in the comments below. As always, I appreciate you folks listening to these videos. Please stay safe. Don't get injured. If you are injured, get healed, get back to work, move on. Okay? And if you're in a really bad place now with your work injury, understand it's bad now. You're going to get better. You'll be in a better place. You gotta heal. You gotta let the process play out. All right? Cool. Thank you. Bye.